Steve Geblin, and we have an interesting case that we want to talk about this week, Steve. This is hot off the presses of the California Court of Appeal. We want to talk about it. It is a case involving JM Manufacturing versus a law firm called Phillips Cohen. And Steve, this case I found interesting because it involves a law firm touting one of its victories, and that's something that all law firms do, of course. And the question is, how much latitude does a law firm have? How much room is it given to engage in puffery without risk being sued for defamation by, I suppose, the loser in a certain lawsuit? So in this case, Phillips Cohen won a False Claims Act case against JM Eagle, and the case involved PVC pipes that I suppose were, the case was really that JM Eagle represented to the government that the pipes met a certain standard, and once they got governmental contracts, Phillips Cohen proved that the subsequent piping did not live up to that standard. Right. So they won the lawsuit, big, great victory. Phillips Cohen, feeling very good, came out with a press release touting the victory, and I suppose expounding upon beyond the verdict form of what the jury found. And so JM Eagle took issue with that. JM Eagle tried to say that the press release should have been very narrow and just focused on what the jury found, whereas the press release was much broader and effectively said that Phillips Cohen prevailed, that the PVC pipe was faulty, it wasn't any good, and governments would be damaged in the realm of billions of dollars. And JM Eagle said, no, the jury just found that they did not comply with this certain standard. And so what happened is that although JM Eagle, it looks like, got whipped in this False Claims Act case, they then sued Phillips Cohen for defamation. I have a hunch there's probably quite a bit of bad blood there based on what happened in the original case. So what then happened is that Phillips Cohen, as the defendants, brought an anti-Slapp motion, and it was that motion was rejected by the trial court, and the trial court said that California's anti-Slapp did not apply, that the case would go to trial to a jury, and at that point Phillips Cohen appealed. And can you tell us briefly what the appellate court found, and then we can talk about some of the larger implications of this, and then we'll get out of here.
Yeah, so what happened at this point, like you said, the trial court found that the anti-Slapp didn't block JM Eagle's case from going forward at the trial court level. Phillips Cohen filed an immediate appeal on the anti-Slapp ruling, which it's allowed to do, and that's why anti-Slapp cases generate a lot of appellate opinions and a lot of appellate rulings.
And when you're Phillips Cohen, then the reason why you want to do that, right, is because the whole point of the anti-Slapp is that as a defendant, you don't expend a bunch of money defending a BS case.
Right.
So if your motion isn't granted, you should be able to get to the appellate court, hopefully win, and then avoid spending money defending a BS case.
Right. The whole point of the immediate appealability is because anti-Slapp is designed to protect exercises of public participation, including your free speech rights in certain areas. The legislature wants to protect people from having to go through expensive litigation. So if a ruling comes down against you on an anti-Slapp, you get an immediate appeal. There's also attorney's fees hitched in there to try and make sure you're not bringing in a meritless appeal, but that's the whole scheme. And anyway,
so what did the appellate court say here?
So the appellate court here said this is protected speech. It's protected under the litigation, under this bridge privilege, which exists between the privilege of the litigation privilege, which is filing anything in court, and the privilege of the press to report on court matters. So there's this privilege in the middle called a bridge privilege, which means litigants and their law firms can report to the press about the government proceedings, the court proceedings.
And so it's important to note that you don't just have to be a newspaper to have access to this privilege. In this case, it was a law firm touting their own success.
Right, exactly, and a press release. So telling the press and the world about something that happened in a government action, in this court case. So that was why it was protected under the Anti-Slapp. So it got under that umbrella. Once the law firm Phillips Cohen showed that it was protected under this privilege, it became the responsibility of J.M. Eagle to show that it had a meritorious case to continue the litigation. And here, because all of the defamation and the statements were undisputed, it was a single press release by the law firm, the appellate court looked at it and said, this is a 3-page press release. It describes in detail, in fairly good detail, and in a fair manner, what happened in the case. The J.M. Eagle can't go in and cherry pick just out the headline and certain words that might be defamatory out of context to try and make it a defamation case. You have to look at the entire context, and in context, this press release was fair, given the wide latitude given to this fair reporting on public actions. So 2 parts there. 1, there's a wide latitude given to this privilege, and 2, this press release, in context, read as a whole, fits within that wide latitude. So no case.
And that's right. And I think at the end of the day, I agree with that finding. And I found it interesting that, again, I think a lot of it came down to the appellate court providing that wide latitude for a law firm. And, look, law firms, a lot of them won't admit it, but they are in the sales business like any other business. And so when they have a success, when Mercedes comes out with a great car, they want to promote that and puff it up. And I think the law firm did the same thing here. I think if the appellate court went the other way, it would be pretty tough on us as lawyers to talk about our cases, to promote ourselves, to display our expertise in various areas. So I think, for that reason, especially for our profession, I think it's a pretty good outcome. I also know that a lot of times we get calls and people, take issue with reporting of, their civil cases. And again, to your point, they want to take out one word here or one word there, but you have to, what this opinion says is you have to take a look at the whole article. You don't just take a look at the headline or a sentence within the article. So context is king, I think, with regard to defamation. I think that's the message here. And so we want to do a quick one this week, but we thought this case was very important in the area of defamation practice and anti-slapp practice. It strikes me, like I said at the opening, that a lot of times there are hard feelings after civil cases, and maybe some of that was going on here as well, where the plaintiff wanted to have another bite at the apple of beating this law firm that won this terrific victory. So that's it for the Raines Feldman Cyber Liability Report. We'll see you back here next time.
Thank you.